was the proximate cause for all these problems?
Your Excellency, when we refer to all these problems...
Well, you know, you're going into the Burgundian, their retaliation, etc. What do you think set all this afoot? The proximate cause. If we were to deal with your submission on the basis, or your case on the basis of proximity of cause, what do you think was the proximate cause for all the difficulties that now you place before us?
Thank you for pointing this out, Your Excellency. Your Excellency, the very proximate cause of this entire controversy is Burgundian's unlawful use of force against us under the guise of self-defense.
Is that correct? Is that your case?
Yes, Your Excellency.
But it is your president, pretended president, who suspended the constitution after Agita had constitutionally claimed its independence and sent forces into the independent republic. So into the independent state. So if you talk about proximate cause, the executive whom you now represent before us is the proximate cause for your own problem. How can you now come and complain to us when you are the cause of the problem? What is your answer to that? Yeah.
All right.
Yes, Your Excellency. Thank you, Your Excellencies, for reminding the court of the principle of approaching the court.
We are not reminding the court, we are reminding you.
I stand corrected, Your Excellencies. Your Excellencies, while we admit that perhaps all these controversies resulted in the internal strife which was caused by the suspension of our Constitution and in the acts of our lawful President, Your Excellencies, Burgundian still had no business interfering in our internal affairs.
But they have refugees inside their country. They were very tolerant, so to speak, and they were bombing, there were incursions into their territory, there were bombing raids, and they have given you warning before the bombing raids, so how can you justify that?
Thank you, Your Excellency. Your Excellency, there is nothing in the Convention on the Status of Refugees which will justify Burgundian's use of force against Doña Valle.
But we are not, I'm talking about general and integrated principles of international law, not necessarily restricted to the Refugee Convention. Of course, Refugee Convention did not say that if they are refugees, we can invade another country. Of course, we did not say that.
I stand corrected, Your Excellency. Your Excellency, there is absolutely nothing in international law which justifies Burgundian's use of force against us. First, on the basis of the norm on non-intervention, they had no business interfering in an internal affair between the Union of Doña Valle and the Agitan rebels.
Your internal affairs sent thousands of Agitans into their territory. You think that was all right? That's quite all right. Is that your submission? I mean, I have to write something down. Is that your submission?
No, definitely not, Your Excellency.
Right. Then what's your submission?
Your Excellency, allow me to repeat my the first two submissions of the Union of Doña Valle. In general, Your Excellencies, the state of Burgundian's use of force on Doña Valle has absolutely no justification in international law, for it violated the norm on non-intervention. It amounted to...
Time is extended by 5 minutes.
Thank you very much, Your Excellencies. Their use of force amounted to acts of aggression against us, Your Excellency. Your Excellencies, they are seeking to invoke lawful self-defense and the support of national liberation movements to excuse the use of force. It is our submission as well, Your Excellencies, that these defenses do not avail in this case and do not make their use of force lawful under international law, Your Excellency.
In 1971, when refugees from what was then East Pakistan flooded the streets of Calcutta, the Indian forces moved and liberated what is today Bangladesh. No condemnation by the UN Security Council, no resolution against them. Isn't that the best example to support the other side? What if they argue that this is a case of all fours with the Bangladeshi example? What is your answer to that?
Your Excellency, it is our submission that even if this case were found to be on all fours with the case of Bangladesh, Your Excellencies, it is our submission that secession and the aid of national liberation movements in secession does not have the status of customary, or rather does not have the status of international law. On the contrary, Your Excellencies, the Declaration of the Granting of Independence to Colonial Territories and Peoples states that the right of self-determination is limited to peoples in a given
How about that? That was 1960, right? And the 1914 December 1960, right? That's the resolution was. But between March and December 1971, as the Chief Judge has pointed out, Bangladesh and also state practice, shouldn't we be entitled to take into account a progressive interpretation of international law and not to the letter of Article 6, right? I think you're referring to Article 6 of the decolonization resolution.
Your Excellency, it is our submission that there is no evidence that the support of national liberation movements in secession has a status or has attained the status of international law. And until such time that state practice has attained uniform and consistent application, and until such time that the support of national liberation movements has had the element of opinio juris sive necessitatis, which would allow it to
So you are saying that there are a lack of both the physical element and the psychological element of state practice regarding secession and national liberation movement. Is that your submission?
Yes, Your Excellency, this is our submission. And until such time that the support of national liberation movements in secession has attained the status of international law, we must abide by what exists, by what is generally accepted as international law in the Declaration of the Granting of Independence, Your Excellency.
But it's only a General Assembly resolution, and Bangladesh and among others, even now Ossetia and others, can't we take into account an emergent principle of customary international law rather than the wording of a General Assembly resolution?
Your Excellency, allow me to address this on two levels. First, we concede that while there may be an emerging norm of international law, it is still emerging and has not yet crystallized or attained the status of international law. Second, Your Excellency, a General Assembly resolution may be evidence of what already exists as customary international law, as stated in the case of Nicaragua, decided by this honorable court, that the participation of states in a General Assembly resolutions is evidence, in fact, of opinio juris sive necessitatis, Your Excellency.
Yes, move on to your next point.
Thank you, Your Excellency. It is further our submission that the use of force by Burgundan against Don Valle is an act of aggression against us prescribed by international law.
You've already said that.
I
You're
stand
repeating
corrected.
yourself.
I stand corrected, Your Excellency. Your Excellency.
Repetition cannot improve a bad case.
Thank you for the reminder, Your Excellency. Your Excellency, our learned friends will seek to excuse their use of force against the Union of Don Valle by invoking lawful self-defense and the support of national liberation movements. Your Excellency, their use of force is neither a lawful use of self-defense nor is it a legitimate support of national liberation movements. Their use of force against the Union of Don Valle is not a lawful exercise of self-defense, for there was no, absolutely no, prior armed attack from the Union of Don Valle. They seek to invoke at least two incidents, Your Excellencies, or rather two incidents, Your Excellencies. The first is the incident referred to by Your Excellency earlier, the unintentional crossing of borders by our military troops into Burgundan territory.
Unintentional? You just now said that you were in hot pursuit of the rebels. Just now, about 10 minutes ago, you said that it was in legitimate hot pursuit.